Israel ratified the UN Convention on the Rights of the Child in 1991. At the time, it was not accompanied by any meaningful public discussion or debate. The ratification appeared at the time as mainly symbolic, a rhetorical affirmation of the obvious, our commitment to children. The realization that the convention carries a transformative message and leads to deep changes in the way we think about children and act on matters affecting them actually came gradually. None of us expected real changes on the ground, and I'm old enough to remember the time of ratification. My presentation will address a significant change in Israeli law that has been tied to the convention, but we'll also try to examine the scope and the limits of this change. I will confine myself to the convention's influence on Israeli law, even though well beyond the law. Its effect can be discerned in the social discourse, the academic scholarship, and the day-to-day practice of so many professionals. I will divide my presentation into three parts. First, the big change, or the revolution, if you want to call it. Second, the limits of the change, trying to look through the conventions for guiding principles at the actual implementation of the convention. And last, I'll try to take stock and look forward. So let's start with the big change, the revolution. In order to understand the extent of the convention's influence on Israeli law, it merits attention that a unique, as you already heard, a unique public committee was appointed in Israeli law in order to re-examine the entire body of Israeli child law in light of the CRC. The committee was chaired by Judge Savion Rotlevi. I served as the committee's vice chair. And the extensive work of this committee is, as far as I know, one of the most ambitious attempts of any legal system to promote the convention's systematic implementation. The committee was appointed in 1998 and published in 2004 6 detailed reports. You see some of them here at the picture. What? No. 19? Okay, we had 6 years. That's my story. I know 6 years, 6 reports. Sounds good. If I'm wrong, I'm wrong. We published 6 detailed reports. You see some of them here at the pictures, relating to the different spheres of children's lives. The committee's work created a platform for absorbing into Israeli law not only the articles of the convention, but the extensive interpretive work of the UN Committee on the Rights of the Child. Its reports are consistently cited in the academic literature and in case law as the canonic interpretation of the convention in Israel. I'm actually very happy we're here on a critical note, but I'm very happy to share with you that although there is still a very long way until we reach full implementation of the committee's recommendations, extensive parts of the recommendations have in fact already been implemented. Sometimes we don't know. You work in the committees, you don't know what actually is going to come out of it. But actually a lot has come out of this committee. Some in the form of new comprehensive laws and legislative amendments, some of which I will be discussing later on, and some through the establishments of new bodies, such as an ombudsman for children in out-of-home placement, and a new unit you will be hearing about tomorrow for child representation, established within the Israeli legal aid system that actually brought about a huge increase in the number of appointments of lawyers for children. In examining the convention's influence on Israeli law, it is almost impossible to separate the convention's direct effect on Israeli law from its influence via the committee's recommendations. And I will be doing it together. I will be addressing them jointly. So where and how can we describe the convention's remarkable influence on Israeli law? First of all, in the legislation. Several statutes allude to the convention as their conceptual and normative basis. For example, the law on the rights of students states in section 1, the purpose of this law is to set the principles for the right of students in the spirit of human dignity and of the UN International Convention on the Rights of the Child. The definition of the convention as the starting point of this law and several other laws that actually refer to the convention in the first declarative statement of the law is particularly significant, as it makes the convention their central normative and interpretive source. Other statutes were extensively amended in light of the convention. For example, a comprehensive amendment to the law on juvenile justice, which anchored a broad reform with regard to detention, interrogation, and punishment of delinquent youth, was based on the Rotlevi CRC report. The legislation that, in my view, expresses the most significant endorsement of the convention is the 2016 Children's Foster Care Bill. This law, which was also based on the work of our committee, places children and their rights at the center and defines government actions on behalf of children in foster care through the lens of children's rights. Legislation dealing with children at risk had so far focused mainly on the authority of the state on one hand and parental autonomy on the other. In centering children and their rights, this law marks a turning point and a paradigm shift. The titles of some of its sections may serve to clarify my point. The right to personal development, the right to stability, the right to participation, the right to cultural continuity and personal identity, the right to information, the right to leisure. Another indication of the Convention's significant influence on Israeli law comes from case law. First of all, a change in the language of the courts. The courts, it's only after the Convention that the courts, first of all, referred to children's rights as a new encompassing doctrine and started talking about children as rights holders. In a number of cases, the courts overturned earlier precedents in light of the Convention. I will not mention them all, but in my view, the most important ruling in this regard was the Supreme Court's decision in 2000 in which all defenses regarding corporal punishment of children were abolished. Notably, this ruling described the time after Israel ratified the Convention on the Rights of the Child and the enactment of the Basic Law on Human Dignity and Liberty as a new era in Israeli law. No doubt then, the Convention's effect on Israeli law has been no less than transformative. Nonetheless, upon a deeper scrutiny, there emerges a more complex picture. In order to attempt such examination, I chose to explore the extent to which each of the four guiding principles of the Convention, non-discrimination, the best interest of the child, the right to life, survival, and development, and the right to participation, have in fact been implemented in Israeli law. These principles were defined by the UN Committee on the Rights of the Child as a cornerstone of the Convention. They were also the backbone of our work at the Israeli Committee. And I will not do it in this order. I will start with the right to participation. I will only be discussing, due to time limits, children's right to participate not in policy matters, which is a totally different issue, but in matters affecting them. The principle of participation, I think that Israel is not a special case in this regard. The principle of participation anchored in Article 12 is undoubtedly the one that has had the most effect on Israeli law. A series of amendments which formulate children's right to participate in court proceedings in accordance with the actual wording of Article 12 have been adopted in Israeli law. Such amendments were enacted, for example, in legislation relating to delinquent youth that I've mentioned, youth employment, and children who are witnesses in court. One of the most significant reforms in this field are the regulations on child participation in family disputes. According to these regulations, special units for child participation are to be established within the Israeli family courts. Children over the age of 6 are to be given the opportunity to participate in court proceedings, either by talking to a social worker, and we have some of the social workers working within these units here with us, or by talking to a judge directly. Ask the child to do this. Only recently, the Attorney General has issued guidelines stating that minors over the age of 12 who are candidates for deportation must be heard before decisions are made in their regard. I believe that these children should be heard at a much earlier age. But the recognition of the right to participation with regard to children who have almost no other rights, I think it speaks to the impact or the power of the right to participation in Israeli law. Significant change with regard to child participation is also evident in case law, as conveyed in the ongoing declarative recognition of children's right to participate and in the significant rise in the rates of their actual participation in courts and administrative proceedings. These changes were at least partially accompanied by a shift in the attitudes of many practitioners as to the importance of child participation. Thus, for example, many of the social workers working within the Israeli family court system who had first shown strong reservations about the idea of child participation in divorce proceedings became actually strong supporters following their actual experience with it. And yet, the change is far from complete. One problem is that often children are still not heard. And when they are heard, there are many problems with the way they are heard. For instance, almost never do children have a feedback after participation. So nobody comes back to them and tells them, this is a decision, this is a reason, this is why you made this decision. The main difficulty, however, in my view, concerns the weight that is to be given to children's views once they are heard. Israeli case law, and in this regard, I believe that Israeli jurisprudence is not exceptional, emphasizes the right to be heard, but does not establish any guidelines on the weight that is to be accorded to their views. The scant research on this topic, including an important article by Professor Rona Shoz, who is here with us, indicate that in practice, children's views tend to be given little weight. The second principle I would like to discuss in examining the limits of the Convention's influence is the best interest of the child as anchored in Article 3. Two main questions emerge concerning the interpretation of this principle. The first relates to the interpretation of the phrase, the child's best interest. What does it mean? What is the relationship between the child's best interest and the various rights mentioned in the CRC? The second is the weight that is to be given to the child's best interest in decisions relating to children. Due to time limits, I will address only the first question relating to the content of the best interest of the child. The UN Committee on the Rights of the Child has recurrently stressed that the CRC must be read as a whole. The child, according to this interpretation, the child's best interest is not in tension or in contrast with any specific children's rights, including children's liberties and the right to participation. In determining the best interest of the child, the various rights should be examined and balanced. This was also the approach adopted by the Israeli CRC Committee. According to our recommendations, the content of the best interest of the child's principle must be redefined in light of the Convention, and this is our definition, as the range of rights, needs, and interests of the child. This is our new definition. which actually try to incorporate this new view, this new meaning of the child's best interest. The committee also recommended a checklist for examining the child's best interest. The best interest of the child's principle had been recognized as a significant principle in Israeli law long before the CRC. But the meaning given to it was vague and paternalistic and subjective. Following the convention and the committee's reports, we can actually find a significant change in the way the principle is articulated in Israeli law. Thus, for example, this new formulation of the best interest of the child as the range of rights, needs, and interests of the child has been adopted in legislation, in the Children's Foster Care Bill, in the adoption law. It is also well reflected in case law. Dozens of judicial rulings refer to the new wording in defining the best interest of the child. In the words of Judge Geisman from the Israeli Tel Aviv Family Court, and I quote, "Today, new meaning should be ascribed to the concept of the best interest of the child, shifting from the paternalistic perspective that had been at its focus to one that views the child as a whole person, as an independent and autonomous right bearer." However, unfortunately, the rhetorical endorsement of the new conceptualization of the best interest of the child's principle is only rarely reflected in the actual decisions of the courts. In most decisions, even those who mention the new formulation of the range of rights, interests, and needs of the child, the court did not examine the specific rights or refer at all to the specific rights of the child that are relevant to the case. Basically, the discussion is very similar to the discussion that we had years before. In the Israeli CRC committee, we deliberated whether we should change the name of the best interest standard or just the content or interpretation of it to reflect the new meaning, to reflect the shift of attitudes to how we make decisions about children. We decided to keep the name and only change the interpretation and the definition of how decisions should be made. We may have been wrong, as the long legacy and perhaps inertia of how courts apply the best interest standards seem to be extremely difficult to change. Children's right to life, survival, and development. The next principle I would like to examine is children's right to life, survival, and development, anchored in Article 6. I will limit myself to the right to development. The recognition of children's right to development expresses a fundamental difference between children and adults. Children are in a process of swift and very vulnerable development, which imposes special obligations on both parents and state. Signs of reference to the right to development can be found in Israeli law and case law in the wake of the convention. For instance, the Children's Foster Care Law, which I've already mentioned, defines for the first time, and I think it's very important, the right to personal development as a right of children. Relatively rare mentions of the right to development are found in a number of court decisions dealing with issues such as the justification for the state's authority to intervene in order to protect children, the prohibition of corporal punishment, and an issue that is now very topical in Israel, the need to refrain from detaining children of immigrants as it will harm their development. Nevertheless, the actual influence of this principle on Israeli law is extremely limited. Neither the legislation nor case law has translated the recognition of the right to development into specific duties of the state. When services for children are constantly being cut, the right to development does not serve as a shield for children. The implementation of the right to development is not a simple task and will require complex thinking of the scope of state obligations. It's a very recognition that this right imposes clear and new obligations on society, which Israeli law has not yet reached, could be, in my view, the key to the change that is probably the most essential in the lives of many children in Israel. And last but not least, non-discrimination. The non-discrimination principle is obviously not unique to children and applies to everyone. According to the convention, however, this principle has special features and importance when applied to children. First, the convention states that children are not to be discriminated against due to acts or characteristics of their parents or family members. Beyond this, however, ensuring children's equality imposes, according to the convention, enhanced obligations, and this is very important, on the state. The reason is that the principle of equality should be read together with the principle of development, on the assumption that discrimination against children is potentially very harmful to their development. Children who are victims of discrimination in services regarding their health, their education, or safeguarding their personal safety are children whose development could be irreversibly harmed. The principle of non-discrimination, as articulated in the convention, has been adopted in some legislation in Israel, such as the foster care bill and the municipality ordinance, which establishes special local committees on the rights of a child. And yet, its real impact on Israeli law has so far been negligible to non-existent. A review of all published Israeli case law found no mention of Article 2. Needless to say that there is no discussion of the unique importance and characteristics of non-discrimination of children. In light of the great challenges and alarming data that we're facing regarding discrimination of many groups of children, such as Arab children, Ethiopian children, children of the periphery, and many other groups of children, the Convention's lack of influence in this area is very troubling. In conclusion, any attempt to sum up the influence of the Convention on Israeli law must grapple with a complex reality. On the one hand, and it's important for me to emphasize this because we're really celebrating the Convention here today, the Convention definitely had a profound effect on Israeli law. At the same time, the limit of the Convention's transformative effects on Israeli law are quite evident. What explains these limits and what can be done to enhance its effect? I can think of three possible explanations. The first is that we're still in the middle of the change and that better implementation will just come with time. This is an optimistic explanation, perhaps an overly optimistic one. A second potential explanation for the limits of the Convention's influence would be a life cycle one. After reaching a peak in the early years, and especially after the committee's reports were published, there is a decline now, and perhaps even some withdrawal in the effect of the Convention. This theory can get anecdotal support by looking at the number of Supreme Court cases in Israel that actually mention the Convention over the years. And we can see a notable rise, really like threefold, between the years 2005 and 2007, after we filed our committee's report, and then a decline in the number of cases in which the Supreme Court mentioned the Convention. The third and last explanation focuses on the text of the Convention itself and its interpretation. The Convention presents a holistic, non-extreme approach. This approach has been the key to the Convention's success all over the world. The downside, however, has been a limited ability to mobilize perhaps more transformative reforms in some areas. What can we do? What can we do to enhance the Convention's influence? On the domestic level, we should keep the discussion going. We should constantly monitor the Convention's effect and vigorously argue for its fuller implementation. On the international level, I think that we should do exactly what we're doing here today. We should recommit constantly to the convention, and work in order to enhance the comparative analysis of the convention's impact in the various jurisdictions. We should learn from success stories of other countries in implementing the convention. No less important though, we should use the comparative lens to locate and define common obstacles to the full implementation of the convention. Such insights can assist in the already amazing work that the UN Committee on the Rights of the Child is already doing, affect its implementation, and perhaps with time, I say this very cautiously, even lead to some changes in the convention. So,